Chapter 1 Course Introduction. This course will highlight the most important concepts and principles in medical and healthcare law, the distinction between the two, the sources and principles of both, and how to apply them. Remember to study this with the written material in more detail. We are experiencing more and more litigation against healthcare providers in the criminal and civil spheres due to the public being more aware of their rights and less hesitant to take on the medical profession. But, as medicine is not an exact science, these cases are often very complex, technical, and difficult to prove, and you should take care not to institute frivolous or baseless actions which may result in expensive cost orders against your client or professional negligence claims against yourself, as attorneys are not generally trained in medical law. To handle these cases successfully, you should familiarize yourself with the medical terminology, procedures, and the specialized law applicable. But how is it different from other areas of law you have studied before? Medical law is a species of healthcare law which relates to promoting public health, organizing various healthcare professions, and ensuring access to healthcare services. Medical law specifically relates to the regulation of the medical professions and the relationship between the doctor and patient, the consequences of breach of duties and offences, which is generally more complicated than usual contractual or delictual relationships. The interplay between various areas of law, including contract, delict, labor, and constitutional and consumer law, will be illustrated throughout. Please take note that when we refer to the doctor-patient relationship throughout this course, this reference includes relationships with hospitals, nurses, specialists, and other health professionals. In Chapter 2, we will look at the relationship between doctor and patient, specifically the nature and terms thereof, the principles applicable, the general duties of each party, the standards of care expected from different healthcare providers, and tests applicable to determine negligence and how to prove it, as well as the pivotal causation requirement. Various examples of medical negligence, like foreign objects left behind and mishaps during surgery, and vicarious liability will also be investigated. In Chapter 3, we will discuss the various grounds of justification for medical interventions and other defenses in medical law, such as emergencies, medical necessity, contributory negligence, and most importantly, informed consent. In Chapter 4, we will look at how the South African Constitution provides for and impacts on medicine and healthcare services. In Chapter 5, we will discuss statutory enactments regulating the medical profession. We will look at how various acts affect areas such as regulation of the various professions, remedies available to patients, complaints and disciplinary proceedings against medical care service providers. The South African health system currently consists of the public and private sectors with some distinctive principles applicable, but both largely governed by the National Health Act, as well as an array of rather complex case law. Take note, though, that this may change, as the government intends to introduce the National Health Insurance System sometime in the future. In the final chapter, we will give practical suggestions on how to approach medical negligence matters in practice and in the courts. After this course, you will be expected to understand the basic concepts in medical law, the sources and applicable principles, and how to apply them in practice.